morning or good afternoon, depending on where you may be joining us today. Thank you for attending today's presentation, Top Employment Law Updates 2025, What You Must Know. While this session is hosted by CISA, the global leader in background screening and compliance-driven human capital and risk management solutions, we're delighted to have attendees from across our family of brands. Whether you registered through PreCheck, Driver IQ, or one of our other divisions, thank you for joining us. Today's webinar is presented by Arnold Golden Gregory, an AAM Law 200 law firm with expertise in industries such as healthcare, transportation, technology, and global commerce. This session has been pre-approved by both SHRM and HRCI for 1 hour of continuing education unit. The presentation is being recorded and the recording along with the slides will be emailed to all registered participants in the coming days. Before we get started, I want to review a few housekeeping items. Due to the high volume of attendees, everyone will be muted to ensure the best experience. If you have any issues during the presentation, you can interact with us using the chat pane in Zoom. If you have any questions for our presenters, you may enter them in the Q&A tab and we'll try to address them at the end of the presentation. Thanks again for joining us today. Without further ado, I'm excited to introduce our speakers, Megan Mitchell and Kevin Coy from Arnold Golden Gregory. Megan, Kevin, please take it away.
Thank you. Thank you very much for the invitation to present today, and thank you everyone for joining us. I'm Kevin Coy. I'm a partner in AGG's Washington, D.C. office. An exciting time of year to be here in D.C. I'm also co-chair of our privacy and cybersecurity practice. And with us today is my partner, Megan Mitchell. Megan's based in our Atlanta office. Megan wears many hats. In addition to being an employment lawyer, she is co-chair of our litigation practice, as well as our background screening industry practice team. We're not providing legal advice today. If you have questions about these issues, be sure to consult with your legal counsel. Our agenda for today. We're going to talk about activity in the new Trump administration. We're also going to talk about updates from last year impacting employers, including federal agency rulemakings and Supreme Court activity. We'll also talk about privacy and background screening law impacting the employment space, as well as predictions for 2025. On the predictions front, we'll probably be predicting as we go, as well as a wrap up on that at the end. We'll move into Trump administration activity, starting with the next slide, which addresses personnel issues. And I should say about this presentation, very fast moving target here. If you're revisiting this presentation later, or if you're viewing it from the recording, be sure to check for subsequent developments. This is a lot of quick changing content in many areas. There have been changes just since we put these slides together, and both Megan and I were checking on various things just before the presentation in hopes of having the most recent updated information for you on various topics. And one of those is on personnel decisions. There's the old adage that personnel is policy, and now we're 10 days into the new Trump administration and change is well underway. When I was putting this slide together, my thought was that this would be the relatively traditional part of the presentation on Trump administration developments, as opposed to the diversity initiatives that Megan's going to be talking about, for example. But that proved not to be the case. In addition to making traditional changes at the agencies, and you see here on the slide where we were at the end of last week, when a new president comes into office, it is traditional, for example, for the president to designate a new chair for independent agencies like the EEOC, the Federal Trade Commission, the National Labor Relations Board. Those agencies are set up on a commission model. There are 5 commissioners slots. Traditionally, those are appointed on a rolling basis to rolling terms, with the president eligible to appoint the chair of his choice amongst the seated commissioners. And so we had that at the EEOC. President Trump named Andrea Lucas as acting chair, and there was a vacant seat when he began last week. At the FTC, he named Commissioner Andrew Ferguson chair, replacing Lena Khan, and he also announced his intention to nominate Mark Mador for an open seat. That nomination, I don't think has formally been made yet, but he has announced his intention to do at the National Labor Relations Board. He named Commissioner or board member Marvin Kaplan to be the new chair, and there were 2 seats vacant. And then at the Department of Labor, he nominated former Congresswoman Lori Chavez DeRemer to be the new labor secretary. She's a former congressperson from Oregon, and she has some pro-labor views, which surprised some in terms of her appointment. Her confirmation hearing is pending. And in the meantime, a career official at the Department of Labor, Vince Mincone, is acting labor secretary. What President Trump did at the end of the week mixed things up a little bit, and that's with respect to both the EEOC and the National Labor Relations Board. President Trump fired commissioners from their seats. In the case of the EEOC, he terminated 2 democratically appointed commissioners, including immediate past Chair Burrows, as well as Jocelyn Samuels, from their positions. And he also terminated the general counsel at the EEOC. For the National Labor Relations Board, similarly terminated Commissioner Wilcox and also terminated the general counsel. Termination of the general counsel is not unprecedented. President Biden did the same thing at the start of his administration. The general counsels exercise a lot of authority within those agencies with respect to their litigation practices. And the termination of the GCs was not unexpected. They're replaced by acting general counsels for the meantime while permanent appointments are pending. What's new is the termination of the commissioners themselves. The agencies are structured on rolling terms, as I mentioned earlier, with the intent that while presidents can have an impact, the structure is supposed to be insulated from wholesale changes at the commission level through the staggered terms. They're only customarily removable for cause. That's the new wrinkle here. And we have to wait and see how that plays out. All 3 of those commissioners that have been terminated have said that they're reviewing their legal options, and litigation is certainly possible over whether that happens. How the agencies react to that is also a little bit up in the air yet. The websites are not entirely predictable, but the National Labor Relations Board has already updated its website to remove the Commissioner Wilcox from their website. The EEOC has not yet done so. They still list Commissioners Burrows and Samuels as commissioners. That could be just a slow updating, but it could mean something more. That's not entirely clear. In the meantime, both those agencies, if those terminations are not put on hold by courts, are acting without a quorum. Neither one of them has the 3 commissioners necessary to conduct business. So they will be limited in terms of what they can do in the coming months until their replacements are confirmed. That will vary a little bit from agency to agency. The EEOC, for example, has procedures in place for instances when the commission doesn't have a quorum that permit some routine litigation to continue at the staff level. There are other things that would require commission action that may not be able to be acted upon until the commission again has a quorum. And so lots of changing dynamics here in terms of personnel and policy. Expected that the agencies will have a lot to do given the president's focus on diversity issues and other employment law issues. And so we'll have to see how that plays out. Also the Consumer Financial Protection Bureau at the bottom of the page, not vastly relevant for this audience, but it does have responsibility for things like enforcement of the Fair Credit Reporting Act, governing background screening. Director Chopra remains in his post there, although he's expected to be removed any day. Who his replacement is going to be is still an open question, so we'll have to see what happens there. With that, let me flip it over to Megan to talk about some of the president's actions on diversity issues.
Great. Thanks, Kevin. There's a lot to cover. So we are going to walk through it as quickly as we can. I'm sure everyone on the webinar today has been following the news that President Trump issued a lot of executive orders in his first 10 days in office. One of those executive orders that we're going to talk about today focuses on DEI, which is diversity, equity, and inclusion. There have actually been several executive orders and memos issued. You can't read any news source without seeing the term DEI. This is clearly a key area of focus in the early days of the Trump administration. So we wanted to spend a few minutes talking about what's specifically in the executive order, understanding that these issues are likely to change, but the administration has expressed its intent moving forward. So on January 21st, President Trump issued an executive order titled Ending Illegal Discrimination and Restoring Merit-Based Opportunity. This executive order was notable because it repealed prior executive orders issued by prior administrations, which is not unusual, but one of these went all the way back to 1965. So especially with respect to government contractors or folks that had been having operations in this space, had understood sort of the rules of the road, so to speak, on diversity, equal opportunity, affirmative action. And there had really been a lot of efforts in that regard and rules in place in that regard. Those things are now largely gone as a result of the executive order. And those prior executive orders had focused on non-discrimination by government contractors. The new executive order orders all agencies to immediately terminate all discriminatory programs and activities, and then to take steps to combat illegal private sector DEI preferences, mandates, policies, programs, and activities. So the executive order not only requires specific actions by federal agencies and other entities themselves, but it may have effects and likely will have effects on private employers. So as an initial step, federal agencies are required by the executive order to issue a report within the next 120 days. That report must include recommendations for enforcing the federal civil rights laws, taking other appropriate measures to encourage the private sector to end illegal discrimination and preferences, including DEI, and to come up with proposed strategic enforcement plans that the Attorney General of the United States would use in consultation with relevant agency heads to formulate civil rights policies moving forward and target litigation goals. So what do these proposed plans include? So President Trump has ordered agencies to identify key sectors of concern within each agency's jurisdiction, and within those areas of concerns, to identify the most egregious and discriminatory DEI practitioners. So that language comes from the executive order. We don't have a lot of additional information about what that means, but you can expect federal agencies to come up with lists of practitioners, including groups that provide DEI training, for example, or who have otherwise assisted federal agencies in prior DEI initiatives. And then those plans should also include specific steps or measures to deter DEI programs or principles, whether they're called DEI or otherwise. We've already seen a lot of agencies remove references to DEI from their websites, for example, remove references to DEI from policy documents. So those steps are already happening at the agency level, and we expect that to have a spillover effect for particularly government contractors, but also private employers as well. So as part of this plan, each agency is also required to identify up to 9 potential civil compliance investigations. So this means that the agencies would recommend an investigation by the federal government into DEI practitioners or entities that engage in DEI practices. And the executive order specifically names publicly traded corporations, large nonprofits, foundations with more than $500 million in assets, higher education institutions with $1 billion or more in endowments, and state and local bar and medical associations. So the administration is signaling where it intends to look for what it views as discriminatory DEI programs that may be targeted for civil litigation potentially or investigations. So that's something that we're watching to see how this unfolds. As I mentioned, steps are already underway at the federal government level to stop diversity activities, to end programs, to change approaches on DEI and refocus those efforts elsewhere. So if you're a private sector company, this doesn't directly affect you today necessarily. For government contractors, it's a little bit different. But there are steps that private companies should take based on the issues that the Trump administration is identifying in its executive orders to be prepared for potential compliance concerns moving forward. And so I'll talk about that a little bit more on the next slide. So some considerations in response to these executive orders. So first, confirm whether you are a supplier or a contractor to any entity of the federal government. If you're doing business with the federal government, there are special rules that apply to you, and these executive orders are likely to have a much more outsized impact on your operations and to have some specific steps that you may need to take. If you're not a federal government contractor, it's also a good idea to think about looking at your own workplace policies and programs and identifying whether you have any programs that include so-called preferential treatment based on gender or race. And these are terms that come from the executive order. So an example might be an internship program or a training program or a mentoring program or an affinity group that has a specific focus on gender or race. Those types of programs or groups may be considered illegal under future guidance or future lawmaking or future executive action that we see. So you want to know what programs and things you're doing today so that you can think about whether there are any changes that you might need to make in response to executive action. We expect that race or gender-based employment or hiring targets are likely to also come under scrutiny. So in addition to more informal programs that you may offer to your employees, if you have set any goals or quotas or targets, measures, anything like that are based on race or gender, be aware that those types of programs may also come under scrutiny. Now, what we're not seeing is any scrutiny of programs that are intended to increase hiring of people with disabilities or veterans. Those programs are supported by the administration based on current guidance, and we expect those programs to continue. But within the range of protected classes that we typically address as employment lawyers, race and gender are the two that are receiving a lot of scrutiny and focus from the new administration. As we mentioned, there is a lot going on with the new administration. It's important to stay up to date. In addition to efforts focused on eliminating DEI, the presidential administration has also signaled an intent to focus on immigration, return to work, and artificial intelligence. We don't have time today to discuss all of the executive orders that have already come out in those spaces or make predictions about what is to come, but we know that these are areas that the presidential administration is focusing on. And so even if you're not a government contractor, even if you're not in the federal government, these issues are likely to affect your business and your employees moving forward. So be sure that you are staying tuned for breaking updates in these spaces. We're going to see a lot of development on these topics. So we've talked a little bit about what has happened in the last 10 days, and we've only scratched the surface. But we also wanted to look back and recap some developments from 2024. This was really a year of push and pull in anticipation of a new presidential administration. So this happens in the year leading up to an election year without fail. Agencies rush to finalize guidance or rulemaking. Supreme Court decisions are always coming out, but 2024 was a particularly busy year for developments in the employment space in particular. So we want to just touch on a few of those and cover one law that we're seeing more and more. Now, to set the stage here, we are going to do a really brief dive into some Supreme Court history. Stay with me. This is a little bit arcane, but I promise we'll bring it all back together. So there's something called the Chevron doctrine. Chevron USA versus Natural Resources Defense Council is a 1984 United States Supreme Court case. All of us lawyers studied it in law school. If we went to law school after 1984, it really changed the scope of administrative law in the United States. And Chevron answered the question of how federal courts defer to agency interpretation of laws and statutes. So Congress passes laws, but typically those laws don't address every single scenario that might affect the enforcement of those laws. And traditionally, Congress has allowed the federal agencies to fill in gaps in the law, and to do that via the rulemaking process, which involves notice of proposed rulemaking, a comment period, revisions to rules, and then ultimately the publication of a final rule that gives more guidance on how the law is interpreted. And oftentimes, many laws are really followed based on what's in agency rulemaking. So when an agency does that rulemaking process, of course, it's not the same as Congress passing a law. So federal courts had to develop a test for whether they would apply the agency rulemaking or not. And so the Chevron case established this two-part Chevron deference test. And courts would use this test to evaluate agency rulemaking. The test is whether the statutory language at issue is clear or ambiguous. If the statutory language is clear, then an agency can't deviate it. But if the statutory language was ambiguous, then the court would defer to the agency's reasonable interpretation of the statute. So that's where this gap filling idea comes in. We operated under this regime for decades, and then in July of last year, the Supreme Court overruled Chevron and did away with that line of cases. There were some companion cases as well on this point. And in this, the case was called Loper-Bright. In Loper-Bright, the Supreme Court held that courts did not need to defer to agency interpretation of a statute, and instead must exercise independent judgment when determining whether an agency acted within its statutory authority. So this is a reversal or a change in course from the prior two-part rule that allows deference to administrative agencies when a statute is ambiguous. So this new Supreme Court decision really gives courts the ability to take a more active role in reviewing agency decisions. It makes clear that ambiguities in federal statutes, which often exist, are not invitations for agencies to supply their own interpretation or expand a statute's reach to matters that Congress did not address. These are things that the Supreme Court signaled with this rule. And so as a result, we expect that Congress will need to enact or amend statutes with greater clarity and specificity if Congress intends for these statutes to survive judicial scrutiny. What this really means is that courts have a much larger role than they have in the past in order to determine the effect of agency rulemaking. And again, we just talked about all of the efforts that agencies are undergoing right now, the power that they have in the economy and the large role that they fill coming into this year. That all changed with the Loper-Bright decision that came out this summer. And we can expect to see a lot more challenges in addition to what happens at the executive level from the presidential administration. Independent associations, independent plaintiffs, any group with an interest in overturning agency rulemaking has more ability to do that after this Supreme Court case was decided. I'll give an example of a few examples actually of how this plays out. And because this is an employment presentation, I want to cover the Pregnant Workers Fairness Act, which is a law that went into effect in June of 2023. So this is a law that's been on the books for a year and a half. It didn't receive a lot of attention. It's fairly straightforward, but it does have a large effect on private employers because it applies to employers with 15 or more employees, which is a fairly low threshold. So most employers are going to be covered by the Pregnant Workers Fairness Act. It requires employers to provide reasonable accommodations, absent undue hardship, to qualified employees or applicants, so prospective employees, who have known limitations that are related to, affected by, or arising out of pregnancy, childbirth, or related medical conditions. So that second bullet point is really what the law says. That's what Congress enacted when this law went into effect in 2023. But in April of last year, the EEOC announced its final rule implementing the PWFA. And so the final rule contains many hundred pages of detail about what this law actually means and what employers' obligations are under the law, understanding that Congress has passed a law that requires employers to provide reasonable accommodations for employees with these limitations. So the final rule that the EEOC published, it explains the definition of pregnancy, childbirth, or related medical conditions to include potential or intended pregnancy, including infertility, fertility treatment, the use of contraception, the termination of pregnancy, including via miscarriage, stillbirth or abortion, anemia, endometriosis, postpartum depression, and lactation, including breastfeeding and pumping. And I use this example from the final rule to show how the agency rulemaking gives a lot more guidance about what pregnancy, childbirth, and related medical conditions means. So the intent of the rule is to inform employers about what kind of medical conditions are going to be subject to the law that Congress passed. And so these are the examples that the EEOC provided in the final rule. So after you understand whether these conditions exist or you've evaluated this for your employees or applicants, the final rule went on to explain that an employee may be considered qualified under the Pregnant Workers Fairness Act, even if the employee is unable to perform one or more essential functions of their job. And so if you've been involved in making determinations under the Americans with Disabilities Act, this might be familiar to you. So there is a process and an interactive process that takes place where employers determine whether an employee with a disability is able to perform the job with or without reasonable accommodations. In the Pregnant Workers Fairness Act context, the final rule announced guidance that an employee would be qualified if the inability to perform an essential job function is for a temporary period, and that essential function could be performed in the near future as determined on a case-by-case basis. And as a third prong, the inability to perform the essential function can be reasonably accommodated. So what does that mean? The final rule says that a temporary period means lasting for a limited time, but it may extend beyond, quote, in the near future. Okay, not super helpful, but we're getting there. What does in the near future mean? The rule states that in the near future generally means 40 weeks from the start of the temporary suspension of an essential function, and that number is based on the length of a full-term pregnancy. What is the practical effect of this language in the rule? It means that an employee's inability to perform an essential function of their job, so let's use an example, maybe lifting more than 50 pounds, may require the employer to relieve the employee of this essential function while the pregnancy-related condition exists, or have other employees cover that essential function during that time frame. And so these can be accommodations that are required in many circumstances based on the coverage under the final rule. So this process doesn't only apply to employees who are currently pregnant. It applies to a lot more employees than that based on the elements in the slide that we just saw. So for many employers who were looking at the final rule to determine how to comply with the Pregnant Workers Fairness Act, or who were receiving questions from employees about reasonable accommodations, we received a lot of guidance, but we also had a lot of questions, right? This is really a big change for employers who are used to complying with the ADA process, but are now being expected to comply with these rules for pregnant workers. And it really has been the start of a new set of claims under Title VII of the Civil Rights Act, and a new set of requests to employers to evaluate how to reasonably accommodate employees who have a temporary condition associated with pregnancy, childbirth, or a related medical condition. The rule comes out in April. Loper-Bright Supreme Court decision comes out in June. And so with this and many other areas, we see immediate challenges and a change in how federal courts rule on challenges to agency rulemaking. So in February, a Texas judge blocked the PWFA, the law itself, for employees of the state of Texas after the Texas Attorney General filed a challenge. After that ruling, federal and private sector employees in Texas were still covered by the law, so it had a fairly limited impact on enforcement. But after the rule was announced, a set of 17 Republican attorneys general challenged the rule and filed suit against the EEOC in the Eastern District of Arkansas. That case challenged the rule's requirements for accommodations related to abortion, and that case was dismissed for lack of standing. So that challenge didn't proceed. In June, the Western District of Louisiana partially enjoined the final rule for certain workers in Louisiana and Mississippi who were religious workers with religious entities. That court postponed the effective date of the final rule's requirement that covered entities provide accommodation for elective abortions for employees, which are not necessary to treat a medical condition related to pregnancy. But it did not delay enforcement of the rule's requirements that terminations of pregnancy or abortions stemming from the underlying treatment of a medical condition related to pregnancy would be covered by the rule. So we're getting really into the technical weeds. And of course, the inclusion of abortion in the final rule caused a lot of challenges by state attorney generals. But this kind of gives you an idea of how we see different outcomes depending on different courts who are evaluating rulemaking. So I use this as an example, not only to alert you to the Pregnant Workers Fairness Act if you weren't aware that it existed, but challenges to the Pregnant Workers Fairness Act final rule are ongoing. The rule hasn't, at least as of today, been withdrawn or modified, although that may come if there are other changes at the EEOC, which are already underway, as Kevin mentioned, or executive orders that address this. And we can expect to see a lot more of this moving forward in terms of very localized challenges to agency rulemaking. And to give you a few other examples of big developments that we saw in 2024, in April, the Department of Labor issued a final rule on the FLSA overtime regulations. These increased the salary levels for white-collar exemptions. They would have made several million more employees non-exempt, meaning that those employees would be required to receive overtime pay. That rule was in effect for a few months. On September 11th, the Fifth Circuit Court of Appeals ruled that the DOL had statutory authority to set this minimum salary level, which was a win for the Department of Labor at a Court of Appeals. But then in November of last year, a federal judge in the Eastern District of Texas vacated the rule on a nationwide basis. So that rule is no longer in effect. But there was push and pull throughout the year, depending on where these cases were status-wise. You may have also read the news about the FTC's non-compete ban, which was announced in April of last year. That rule would have banned almost all non-compete agreements in the United States. That rule was set aside by a federal judge, also in Texas, this time in the Northern District, on August 20th, 2024, right before that rule was set to go into effect. Another EEOC rulemaking or guidance document that was challenged in last year related to harassment in the workplace. This EEOC guidance document contained a lot of detailed guidance for the EEOC, which would then be relied upon by private employers who were working to prevent or comply with EEOC guidance on harassment, sexual harassment, discrimination, and retaliation. That guidance document was also challenged by more than a dozen states. They were arguing that the EEOC's position went beyond Supreme Court precedent, and the EEOC fought back against that litigation for months. And then within the last 10 days, when the executive orders on DEI were issued, the EEOC informed the court in that case where the challenge was pending that it had been directed by the president to rescind the guidance. So again, we haven't seen that happen yet. We're likely to see existing guidance or existing rulemaking change, be rescinded, go away altogether, depending on what happens with administrative priorities. So it's a really active time in the employment law space. There are a lot of changes, and there's a lot to pay attention to, both as we react to changes in 2024 and anticipate changes in 2025. And so with that, I will turn it over to Kevin to address developments in the privacy and background screening spaces.
Thanks, Megan. The privacy space continues to see developments as well, and we'll look first at federal privacy developments and then some developments at the state level in terms of what's happened during 2024 and what we look to see in 2025. At the federal level, the Consumer Financial Protection Bureau, as I mentioned earlier, has responsibility for enforcing the Fair Credit Reporting Act and rulemaking authority under the FCRA. Other agencies enforce it as well in discrete areas, but the CFPB has primary authority. The agency last year updated the summary of consumer rights that's to be distributed under the FCRA in various instances, including in cases where an employer or a prospective employer is considering taking an adverse action, the so-called pre-adverse action process. Part of that process is to provide the consumer with a copy of the FCRA summary of rights that's been promulgated by the CFPB. And there were some updates to that made in 2023. Use of that new form was required by March of last year. Just something to check if it hasn't already been incorporated into your processes, particularly if you're producing those internally as opposed to through your screener. The CFPB has also proposed a number of FCRA rulemakings, including one in December, which for the most part focuses on areas other than employment. But it does have the potential, if it was adopted, to expand the reach of the FCRA into areas where it's not applicable today, under a variety of theories that have been in place for many years. If that were to happen, it could bring additional services within the FCRA's scope, and that could have an impact on employers. But this proposed rule at this point is a big if. It remains to be seen whether the new administration, the new CFPB, once President Trump appoints a new director, as we were talking about earlier, is widely expected, will proceed with this rule or significantly scale it back, but it is something to keep on your radar. Another rule to keep on your radar, particularly if you have members of your workforce that are overseas, the Department of Justice has issued a final rule on access to bulk U.S. sensitive personal data by countries of concern. That includes not only countries like Russia, Iran, Cuba, Venezuela, but also includes China, including Hong Kong and Macau. Uh, it does have restrictions on employment agreements that would facilitate employee access to bulk data. And this could be a wide range of information, whether it's health information, genetic information, financial information, certain covered identifiers like government issued identification numbers, marketing identification numbers. The rule covers a wide swath of potential data if it's in bulk. And whether it's considered to be in bulk depends on what type of data it is. It could range from 100 individuals to 100,000 individuals, depending on which categories you're talking about. And in the employment context, there are some exceptions related to multinationals exchanging information that's incidental to their employment activities. But there are also cases where employment could be implicated by the final rule. If, for example, your organization hired workforce members from a country of concern, someone that's based in, say, China or Hong Kong, those could be, and as part of their work for the company, they would have access to information that would constitute this bulk sensitive personal data. Say a large data lake of personal identifiers that are covered by the rule or health information. Then those would be restricted transactions under the regulation in many instances, and additional safeguards would have to be considered to see whether or not those types of relationships and that type of access can continue. That rule is scheduled to take effect this spring, although it's possible that the Trump administration will delay its effective date. One of the other executive orders that the president issued in the last few days wasn't specific to this rule, but asked all federal agencies to look at final rules that have not yet taken effect and consider delaying their effective date by an additional 60 days so that the new administration could consider them. That hasn't happened yet with respect to this particular rule, but it could happen in the coming days. Another area where there's been federal activity in the past year is the Department of Health and Human Services has made some amendments to the HIPAA privacy rule, and they've also proposed amendments to the security rule. In the employment space, this often comes up in the context of employee health plans, which are often considered to be covered entities for HIPAA purposes and are administered by the company on the plan's behalf because they don't typically have employees of their own. And so HIPAA often applies in that context. If you have those types of plans that are covered, you may have revisions to make to your privacy notice if those haven't already been done to comply with the new rule. You also, looking forward, may have to review your HIPAA security program because HHS proposed in December broad changes to the HIPAA security rule. That rule hasn't really been updated since it was first adopted in 2013. And HHS has come out with proposed restructuring of that rule to effectively modernize it and institute additional protections. That's only in the proposed rule phase. It's open for public comment now. So again, we'll have to see whether and to what extent the new administration decides to proceed with that rule and what steps they make. But it'll be something to also keep on your radar. Shifting to the state and local level, we continue to see activity here, and it's a mix of new activity as well as continuation of trends that we've seen over recent years. In terms of state privacy legislation, states continue to adopt the new generation of privacy statutes following California's adoption of the California Consumer Privacy Act 7 years ago or so at this point. About 20 states now have legislation, and more are expected to pass them this year. They have each have their own triggers for applicability. Most of them exclude employee data, but not all employee data is excluded in all cases. So you'll want to keep that in mind and consider that in the context of where you're operating. California, for example, covers employee data. It's not excluded, it's expressly included. And so if you have a workforce in California, in addition to considering the implications of that law, if it's applicable to you on the business side, it's also relevant on the HR side. Also in Colorado, we see last year, Colorado passed some amendments to the Colorado Privacy Act, which had previously largely excluded employee data, but they've made some amendments addressing the use of biometrics. Some of those provisions apply to to businesses broadly. Others are specifically written with employment in mind. So while employment is out of scope for much of the Colorado Act, these biometrics provisions will apply when they take effect next year, or I'm sorry, in July, with respect to the use of biometrics in the employment context. And the Colorado Attorney General's office is in the process of finalizing regulations to further implement those Colorado amendments. They're awaiting final approval in Colorado. So that's something new. It puts Colorado more akin to Illinois, which has long had a rigorous biometric privacy act. Texas and Washington have also had standalone biometrics laws. Colorado is taking a similar approach here, although doing it under the rubric of their general privacy law. And as you look at other state privacy laws, biometric information can have some additional safeguards required under those laws as well, to the extent that they're applicable to the employment context. Turning to artificial intelligence, and we'll touch on this more in a moment, but Colorado and also Utah have enacted AI consumer protection laws. They vary in terms of what they cover. Could very well be the start of a trend across other states. Many other states, as well as the federal government, considered AI legislation last year. Not a lot of it made it across the finish line, but Colorado and also Utah did. And so to the extent that you're doing business in those states and you're using AI technology as part of the HR process, that's something to consider to assess your obligations there. And we'll touch on that more again in a moment. We also see continued activity in the fair chance ban the box space and also in the salary history space. The former restricting the way in which criminal history information is considered as part of the employment process, the salary history question affecting the way that salary history is addressed during the hiring process. In those contexts, just continuation of earlier trends as additional jurisdictions adopt that type of legislation, sometimes adding their own wrinkles in terms of additional notice obligations, additional factors to consider as a part of processing that information, which vary from, in the case of California, go further than California's statewide requirements for fair chance and ban the box, for example, with Los Angeles County and San Diego County bringing additional content online. Also, adding additional restrictions on the use of criminal history information. The Prince George's County, Maryland amendments, for example, PG County being here just outside of Washington, in addition to regulating the use of criminal history information and when it can be considered in the process, as these laws sometimes do, also restricts the ability of employers in those jurisdictions to consider particular types of criminal history information, which the county has concluded should not be considered by employers or should only be considered by employers for a certain period of time. And similarly, early last year, Philadelphia passed some amendments to its longstanding law. Similarly, on the salary history space, Minnesota adopted legislation that went into effect the beginning of last year, regulating the use of salary history information. And at the local level, jurisdictions like Columbus and Lehigh County also put controls in place. And looking at going back to AI for just a moment, we won't go through this slide in great detail, but the Colorado AI Act takes effect February of 2026. I think I misspoke a moment ago and said it came into effect yet this year. The law regulates two categories of person: the developers of AI and the deployers of AI, essentially the users of AI systems. So if you're developing your own AI tools for HR in-house in doing business in Colorado, you'd be potentially regulated here. In addition, if you're a user of someone else's AI system, you also could be regulated here. Mention Colorado, not only for its potential applicability in Colorado itself, but also the states tend to like to copy each other when it comes to state legislation. So what we see in Colorado could readily appear in legislation that other states adopt moving forward. It's something to think about as you're considering AI use cases in-house as to how it would line up with these types of protections. One of the things the Colorado law does is prohibit, or at least require, parties to take a duty of care to prevent known or reasonably foreseeable risks of what it calls algorithmic discrimination, basically using AI in a discriminatory manner to take action against protected classes as defined in the Colorado law. It also has additional safeguards for activities that it considers to be high risk under the law, and that includes employment decisions as well as other things like housing. And if you're engaging in these types of activities, then you have to have additional controls in place, whether that's a risk management and policy program. You may need to conduct impact assessments on how the AI tool would affect consumers. You may have to make a series of consumer disclosures in the course of using AI tools. You may have to make public disclosures on your website about your AI use cases. If you use AI and you take an adverse action against someone using an AI system, you'd have an obligation to provide an adverse action notice. And that's a notice that's separate from what's under the Fair Credit Reporting Act, for example, if you're using a consumer report, although the concept is similar. If you're using AI to make an adverse decision, you'd have adverse action notice requirements here. Similarly, you could have an obligation if you're using personal data in the tool to provide an opt-out for consumers. Crossing over to the state privacy laws we were discussing earlier, many of those laws have restrictions on the use of automated decision-making or profiling, in which if you're doing that, you need to provide the consumer with the ability to opt out. The particular requirements around that vary from statute to statute, but it's possible, and the Colorado law specifically cross-references, that if you're using personal information in an AI tool, you may need to provide an opt-out opportunity for the consumer. This is going to be enforced by the state attorney general, and there are some exceptions and carve-outs. It's not all encompassing. But if you do determine, for example, that you have used AI in a way that has had discriminatory effects, there are notice obligations in there to inform the California AG of that. And as I mentioned earlier, the AG is authorized to issue regulations under this law as well. And so that's what we're seeing at the state level. What does it all mean? Sort of wrap up, we've been giving predictions as we go along. I think we expect to see a lot more activity at the federal level as the Trump administration continues to find its footing and to move forward on the executive orders we've received just in the last few days, as well as other changes that the administration will look to make, particularly as its appointees are confirmed and can take full control of their agencies. From a privacy perspective, we will see a lot of activity, I think, continuing at the state level. Privacy isn't in and of itself a partisan issue, and states in red states and blue states are all moving forward with different types of privacy legislation, AI legislation. Megan, any closing predictions from you?
Just stay tuned. There are going to be a lot of changes, but we've already gotten a lot of information about what the priorities are at an executive level. So stay tuned. Think about how those executive announcements are going to impact your own private workplace. And it's going to be a really interesting year for all of us.